Hello everybody, this is TJ Scott with the Law Office of Timothy J. Scott. I am a Minnesota estate planning attorney and I can be found online at tjslawoffice.com. Today I want to talk about the difference between a living trust and a will. Both are often found in an estate plan, but what would your estate plan most benefit from having? So today I want to define each of those terms first, and then I want to talk about when you might prefer planning with one tool, one of those legal documents versus the other. So again, a will and a trust are both legal documents, both allow you to transfer your assets at your death, but they both do so in different ways. Let's start with a will or a last will and testament. A will is a document that lays out certain important decisions of the testator, that's the person who is actually writing the will, that govern their estate after they die. It's important to note that a will is not effective until death. But with a will, that testator can state who is going to receive their assets. Those are called the Disposition Instructions. Without a will, this is often decided by the intestate statutes of your state. Here in Minnesota, we have intestate statutes that essentially say a lineal descendant should be the first to receive. So if there are any children, grandchildren, great-grandchildren, or great-great-grandchildren living, that is the preference for the first person to receive your assets. If not, it goes up to your parents' level, then down to brothers and sisters, nieces and nephews, and tries to find somebody in your family who can receive your assets. If that isn't a good system for you, then you really need to get a will in place to ensure that the person you want to receive your assets is going to be able to. A will can also appoint an executor, or here in Minnesota we call them a personal representative, who has certain powers and is able to oversee the administration of the will and the will often lays out those powers as well. A will can also appoint guardians for minor children and create testamentary trusts, which are trusts that spring into being after the testator has died. If the testator owns real estate or has assets worth more than $75,000, then a will requires probate in order to appoint that executor and to dispose of the assets. A revocable trust or a living trust is an agreement, and it's where one party, called the settlor or grantor, gives property to another party, called the trustee, and the trustee promises to follow the rules that were set out by the settlor. So the trustee is receiving property and promising that settlor to administer the property according to the rules that that original property owner has laid out, generally in something like a legal document. You can also name a beneficiary in a living trust or in a revocable trust, and that beneficiary is the person who has the right to benefit from the property in a trust. In a living trust, the beneficiary is generally that settlor. So the settlor is the person who starts with the property. The settlor is also the person who is receiving the property and promising to follow the rules that they laid out as settlor. And they're also in that third role, the beneficiary role, so that they can use the assets for whatever they choose during their lifetime. Again, this is generally laid out in a legal document so that it's very clear to the trustee exactly what rules they're supposed to be following for the property that the settlor has given them. The trustee also has a successor named, which is the person who can step into that trustee's shoes after the original settlor and the original trustee have died, so that they can take over administering the assets of the trust on behalf of that original trustee. Something very important to note is that the only assets that the trustee is overseeing are the funds that the settlor has given to the trustee. So, for example, if the settlor forgets to record the deed on their home and put that into their trustee's name and the name of the trust, then unfortunately, when they pass away, the home isn't already in the trust and needs to get to the trust in another way. This is generally done with something called a pour-over will, but if you remember, anything that is governed by a will, any real estate or any assets that total more than $75,000 have to go through the probate process. And that's what would have to happen here for that settlor who forgot to record the deed. That home would have to go through the probate process in order to get into their trustee's hands so that their trustee can follow the rules laid out in the trust agreement and dispose of the property or distribute the property in the way that the trust tells them to. So, should you have a will or should you have a trust? And the answer to that, unfortunately, is a very lawyerly, it depends. Everyone should have a will as a part of their estate plan. A trust, again, is only effective for the assets that have actually been given over to the trustee or funded into the trust. And sometimes settlers make mistakes and they forget to put something into the trust, in which case you really have to have a will to back that trust up to ensure that that asset is not lost or subject to the intestacy statutes. In a trust-based estate plan, the lawyer will often create what's called a pour-over will, which is what I was talking about before, that ends up taking any assets in the settler's name at their death and giving them over to the trustee so that the trustee can administer those assets. However, keep in mind that pour-over will has to go through the probate process, which again requires a lot of cost, time, and the public exposure of all of the assets and who is receiving the assets under the will. A trust is often beneficial to avoid probate, and when written in the correct way and funded in the correct way, it can be very effective, a very effective way of doing so. So here's a general rule of thumb about when a living trust versus a will is more beneficial. A living trust, a living trust is generally beneficial, and you should talk to an estate planning attorney to see if it might be beneficial in your case if you own real property or if you have assets worth more than $75,000, including things like personal property, cars, bank accounts, brokerage accounts, or a business. Then you really should consult with a lawyer to see if a trust-based plan makes sense for you. My name is TJ Scott. I am a Minnesota estate planning attorney practicing out of the law office of Timothy J. Scott. And again, I can be found online at tjslawoffice.com.